All rise. The Court of Appeals, First Appellate District of Ohio, with the Honorable Marilyn Zayas presiding, is back in session. Please be seated.
All right, good morning again. All right, thank you for waiting. I know that was a longer than usual wait. Okay, so we are now here on Norton Outdoor Advertising, Inc. versus Board of Zoning Appeals, Village of St. Bernard. If you want to come forward. Attorney Galasso?
Yes, Your Honor,
Did I say
Mike
it right?
Galasso.
Galasso, okay, Attorney Galasso. Would you like to reserve time?
Yes, Your Honor, I'd like to reserve 5 minutes for rebuttal.
All right, whenever you're ready, you can start.
Thank you. May it please the Court, Your Honor. Mike Galasso on behalf of the appellant, Norton Outdoor Advertising. This case is not about whether the Village of St. Bernard has the authority to regulate billboards. They clearly do. The case is about whether they have to administer the ordinances they have as they have them, not as they think the spirit or intent might be, and that those ordinances also must pass constitutional muster. So I had filed a notice of supplemental authority that indicated that what I wanted to do was reserve the constitutional issue for the second part of my argument, because the court is supposed to decide the case on non-constitutional grounds first, if possible. And so I just wanted to jump right into that. One thing that I do agree very strongly with the Sixth Circuit about is the statement that they made that the ordinances are, quote, not a model of clarity, end quote, okay, because they're a mess. And there's capitalized terms that are not defined, there's defined terms that are not capitalized, there's other terms that are not defined at all, and then there's conflicting terms. And so it becomes a little bit difficult to construe the ordinance. But here's where I think I can make it a little bit simple without delving into all these definitions. And that is that the state of Ohio governs billboards through Ohio Revised Code Chapter 5516 and then the OAC provisions in 5516. And so those rules apply to what are called controlled routes or interstates. In St. Bernard, they've got a zoning section, it's 1185, and you start there for signs. But then once you get through the sections, and it does define a sign as a billboard in Chapter 1185, but then once you get down to 118501C, it says Cap E, Expressway, Cap A, Advertising. And then it says refer to Chapter 711 for definitions, rules, and penalties. And so at that point, if you've got an expressway advertising sign, you're out of the zoning code and you're in the business regulation code.
So, counsel, to that point, I noticed that the penalties for 1185 and 711 are different in some really fundamental ways. First of all, the fine, a daily fine is different. It's $1,000 a day in 711. It's $100 a day in 1185. 1185 has an injunctive relief component that 711 doesn't have. And then 1185 has a misdemeanor attached to it that 711 doesn't have. Which set of penalties applies? Do they both apply? Does only one apply? And how do we know that?
Okay, Your Honor, so only if they're enforcing the provisions of 711, only the enforcement mechanism of 711 is applicable and not 1185. And so it is.
So it would depend on the notice that is given? The violation notice?
Yes, Your Honor. So for instance.
So they can pick and choose?
Well, they elected not to enforce. Well, what they did was they said there are two violations, one of which is not at issue on appeal because it was abandoned below and we prevailed on it. So there's one left, and that one is you can't have a digital off-premise sign. And so that's the only piece that's left, and it's only in 711. It's not in this other piece in 1185.
The violation was 112507. That was the violation.
So, yes, Your Honor, 112507 says that you can't use land or a building in derogation of the zoning ordinance.
And they said that the problem was the digital sign in 711.
That's correct, and 711 is not part of the zoning ordinance. The zoning ordinance defines 5, 7, and 9 as part of Part 11 as the zoning ordinance. So it's a business use regulation that's separate and apart from zoning. City of Cincinnati does the same thing. They have Chapter 895 that governs outdoor advertising, then they have a normal zoning code that would govern other things. So what we're arguing is that they didn't have the ability to enforce the business regulations in 711 through the zoning code, which 1185 is actually implemented through 1125, that they didn't have the ability to do that they didn't follow the process that was required. We didn't have the hearing that was required. The notice of violation came from a different person that's not authorized under the ordinance.
So
to
they
give
should
it.
have said the violation was the violation of the 711, not the violation of 1125.
Yes, Your Honor, they should have
Okay.
used the enforcement mechanisms in 711.08, which they did
Okay,
not do.
okay.
And then would they be limited to the $1,000 a day fine and no injunction?
Yes, Your Honor, they would be limited to the fine, whatever the enforcement mechanism would be. However, that gets me to the merits of my argument, which is not, so now we've just been speaking about what ordinance is applicable, but then when we get to the zoning, or I'm sorry, the business regulation code itself, what's at issue is when you get to section 711.06, it says that when an outdoor advertising sign or device is visible from one or more highways, one of which is an interstate with a capital I, then the requirements applicable to cap I interstate, cap H highways shall apply, not defined. Now, 711 does define interstate, and it defines I-75 where this sign is located. And so this sign is to meet the requirements that are promulgated by ODOT according to section 711.06. But what the village wants to do is say that what we mean is in addition to 711.06, you have to also meet 711.07. But that's not what their code says. So they have one set of regulations for signs that are on interstates, and that would apply to ODOT, and all of the requirements are met for that. They have ODOT permits for these signs, they're in the record, and those relate to the size and the spacing and the setback. It does not then apply additionally on top of that, those provisions in the zoning
I
ordinance.
didn't understand that argument. Okay, why are you saying that 71107 doesn't apply?
Because 711.06 applies to signs that where one or more is visible from at least.
Right, so you have to
one-
follow,
So you would apply that. It does not say in addition to, and actually, when we briefed this at the administrative level, I provided an example of a township code from Licking County that said, if you're regulated by ODOT, you must meet those requirements and these requirements, but that's not what this code says. This code says that if you fall into 711.06, you meet the ODOT requirements.
so you're saying that the way you read this is that digital signs, if they're visible from the interstate, because their ODOT says they're fine, that you can have one. But if they're not visible from the interstate, then you have to go back.
That's
Can't
correct.
have one.
Yes, Judge. So, correct. So 711.06, if you're that particular sign that's visible from two highways, one of which is an interstate, then you meet the state requirements. If you're not that sign, you could be on the interstate but not visible from another highway. You could be not on a highway, and then you would be subject to 711.07, which are different regulations
And
on top of.
no digital signs.
That's correct.
Okay.
All right.
Counsel, I want to ask you about our standard of review. Case law directs us not to reverse the decision of the trial court unless there's been a mistake of law. If there are reasonable interpretations of these very confusing ordinances going both ways, how is there a mistake of law for the trial court?
So, Your Honor, you're right, the standard is different at the appellate court than it is when the common pleas court is reviewing the administrative decision. And in 250604, it's unconstitutional, illegal, arbitrary, capricious, unreasonable, or unsupported by substantial, reliable, probative evidence. Well, the evidence is just what came in on the administrative record. And so the issues here are basically statutory construction, and these restrictions on property rights are in derogation of common law rights, and so they're strictly construed against the government and in favor of the property owner, in this case, the lessee. And so that's the legal error. One of the things that you read 1185 to understand that now we're expressway advertising, we go to 711. But there are signs that could fall within in 1185. There are signs that might not be expressway advertising signs. But what the village argued at the Sixth Circuit is the exact opposite of what they argued in their second issue presented before this court, where they say 711 is incorporated into the zoning ordinance. Because if you look at page 8 of the Sixth Circuit decision, at the top, that's the exact opposite of what they said. They say that the village argues that 711 and 1185 operate independently, and they actually prevailed on that issue, and the Sixth Circuit held that there's a lack of redressability for anything that's in 1185 because we're covered by 711, which is expressway advertising. So I think that the doctrine of judicial estoppel applies to prevent the village from coming here today and arguing the exact opposite of what they just argued at the Sixth Circuit. Lastly, just to address the constitutional issue, we have raised from the outset really two things, and on page 152 and 154 of the record, we've always said that 1185 is not applicable. It's different from 711, but then we've also said that the ordinance must also pass constitutional muster, and so the village has the burden of proof on that. They have to show a compelling governmental interest that's narrowly tailored. We put in evidence of other people that had digital off-premise signs, a church and a school in the administrative record. And we believe that, just as the Sixth Circuit found, that this doesn't survive strict scrutiny. Now, lastly,
Counsel, I have a couple of procedural questions for you about the interplay on the constitutional issue between what the federal court has done and here.
Okay.
Did the village seek younger abstention in federal court?
No, Your Honor.
And did you file an England reservation?
I don't know what an England reservation is.
Okay.
So I'll say that we don't.
That would be to ensure that the federal court and not us resolve the constitutional issue.
No, because the way I viewed that at that time was that under 2506, that this court would essentially not perform a facial challenge, that it would only be an as-applied challenge, and so that it would only be bound by this particular notice of violation that's in this case, whereas in the federal case, we have pled out the other additional 8 signs that my client has in the village as also being unlawfully restricted. So it's broader, and it's a 1983 claim, and it's not just an administrative claim.
Thank you.
Thank you.
Thank you.
Thank you, Your Honors. May it please the court. Jesse Nolden here on behalf of the St. Bernard parties. And I'll just start by saying I agree also that these are not the most clearly written ordinances. And I also agree with the Sixth Circuit that Norton has lodged so many constitutional issues in this case that it's, quote, one is left to wonder whether a more constitutionally offensive scheme could exist. And so I think this case has been, as evidenced by this binder of pleadings from just the administrative appeal, really overcomplicated from the beginning. And it really is simple when you go back to the administrative appeal, what the issues are here today. First page of Norton's brief in support of the administrative appeal filed back in 2019 says, there are 2 issues before this court. 1, was there a violation of Ordinance 112507? And 2, are the village's codified ordinances unconstitutional? Now, the constitutionality issue, we maintain that this is a facial challenge that cannot be brought in an administrative appeal, and that this
Is
court-
there even an as-applied claim in this case for us to consider? What would that look like?
Not that I'm aware of. I don't see the words as applied in any of the briefs for the administrative appeal. But if there were, it would not be St. Bernard's burden to show the constitutional issue. It's the challenger's burden in an as-applied challenge to show a constitutional issue. And they've always maintained that it's our burden, so I think that's even more evidence to show that this is a facial challenge and not an as-applied challenge.
Is there anything in this record to substantiate your substantial interest in this ordinance or why it's narrowly tailored? Would we need to look to the federal court action for that information?
I think you need to look to the federal court action for that. And what the federal court did was look at the purposes clause in the ordinances, and consistent with case law, they stated that that satisfies the burden in terms of intermediate scrutiny, satisfies the burden.
Would you like for us to do that to the extent that we would reach that question? Would you like for us to look at those federal decisions for that information?
Yes, if this court's going to examine these ordinances on a content-based challenge, I think that's the way that you would find that St. Bernard has met their burden. For an as-applied challenge, I don't think Norton has ever met their burden to show that there's a constitutional issue.
And what specific burden do you think that Norton has?
Your Honor, it's the case, Supreme Court of Ohio, Jalen Investments Incorporated v. Village of Moreland Hills, that's 107 Ohio State 3rd, 339. Challenger of the ordinance has the burden, and the proof, standard of proof is, quote, beyond fair debate. So it would be beyond fair debate that somehow the ordinances or the decision of the Board of Zoning Appeals as applied to this sign or this decision raises some kind of constitutional issue, and frankly, I'm not sure what that is because I don't believe it's ever been made.
Right. And can you address for me the difference in penalty between Chapter 11 and Chapter 7, and what penalty it is that the village is actually seeking in this case?
Yes, Your Honor. So there are separate penalty, or separate, I'll call them enforcement provisions in Chapter 711 and Chapter 1185, or 1127, that is. And as far as I know, no fines have been levied at this point. I know that's been brought up, but because this has been on appeal since, frankly, 2018, the village has not actually imposed any fines at this point. But there are separate provisions in 711 and 1185. This one is 1125. This one is 1125. Those are the penalty provisions that apply to this.
All you have sought is for the sign, discontinued usage of the sign.
At this point, I do believe there will be, at some point, a fine imposed. But at this point, all it has been is for the sign to be deactivated.
And so that's a penalty or an enforcement remedy that falls under the Chapter 11 piece, correct?
Correct. The notice of violation was issued pursuant to Chapter 11, not pursuant to Chapter 711.
Okay, so those are the standards that the village has to fulfill in order to get that remedy.
I'm not sure I understand.
Well, we'd need to look at Chapter 11 and all that's required there in order to ensure that the village had satisfied a violation.
Yes. Now, the violation is Chapter 112507, which basically says you can't violate the zoning code. The violation of the zoning code is found in Chapter 711. So they're saying the violation of this zoning code is this violation of Chapter 711, which is the multi-message advertising sign.
So why are there two separate penalties then?
Well, 711 could be enforced on its own. There could be a standalone violation of 711. I think this 711 at some point mentions the tobacco sign. So, and there's an informal hearing in Chapter 711 as opposed to a formal hearing in Chapter 11. So something small, the village could decide to, like a tobacco sign, the village could decide to just have an informal hearing and a notice violation on that. Or when you get a zoning permit like this sign has, spend over $400,000 in construction costs to install these signs, that's a big issue. So a more formal hearing, a violation of the zoning ordinances is more applicable here because there is a zoning permit that was issued, and that was, after it was issued, the village felt that the sign went beyond the scope of what was put in the permit, so it was a revocation.
So the village thought that they were issuing a permit for a static sign, not a digital?
It said digital in the application, but it didn't say anything about multiple messages or flashing messages.
Well, wouldn't that be what a digital sign's for?
It could be, but the digital sign didn't, or the application did not say multiple messages. It did say digital. I believe it did use the words digital.
I think it's used LED.
Yeah. So yeah, because the illumination was an issue 1.2, so the village knew it would be illuminated, but
They didn't realize that it would be a flashing multi-message situation
Correct.
until after they built it.
Correct.
Okay.
And so is a sign a use of land?
I believe it is. Yes, it's a use of land. I mean, the sign is on land. It is a use of the land that violates the zoning code. I don't think that the ordinances require a village to put anything that could be on land in them in order to describe what violates the zoning code. And I don't think there's any argument that could be made that Norton couldn't be aware that this would be a violation of the ordinance because they're not aware that this is on land.
Is there a use table in the village's zoning ordinances?
I'm not sure. I'm not familiar with one. No.
So we have to determine that Part 7, the business regulation code, is part of the zoning code,
Yes.
and that's what the judge below determined.
Yes, that's what the village determined and what the,
And why is that? Why is it part of the zoning code?
it's chapter 1185, 1185-01C. And everyone is in agreement that 1185 is in the zoning code. And so when it gets to chapter 1185-01C, expressway advertising, it says, please refer to chapter 711 of the codified ordinances for definitions, rules, regulations, and penalties. And so that, right, instead of restating, typing out everything that they already put in chapter 711 into 1185, it just says, here are the rules, regulations, definitions, and penalties.
But doesn't that suggest that the penalty that would apply for expressway advertising is the one that's set forth in chapter 711, and that's limited to a daily fine?
It does suggest that, but 711 could also be operated independently because, like I said before, you could have a standalone violation of 711 that they could choose to prosecute under 711, or they could choose to prosecute something like this where there's a zoning permit for a violation of the zoning ordinances.
So the village could have said that they could have said the violation was 711 instead of what they said.
Correct, yes.
They could have done either one.
They could have done either one. There was a zoning permit issued, and that's, I believe, why it was operated under 1185, which is a violation of the zoning ordinance. They could have proceeded under 711. It would have been procedurally, factually, legally probably easier for them to have done so, because then you lose the argument of whether 711 is actually incorporated into 1185, and then you just get right to the merits of the argument, and there's not really any factual dispute that the sign does fall into the definition of 711. So it's just a question of, is 711 part of 1125? But I think because this was such a huge project, there was a zoning permit issued, this went beyond the scope of that zoning permit. I think that's why they went for the full formal hearing before the Board of Zoning Appeals, as opposed to the more, says right in the statute, informal hearing that will have sworn testimony.
And then you would have to, then we have to get into whether 71106 stands by itself or whether it must be read in conjunction with 71107.
Right, and this one, I've also frankly never really understood this challenge to this. And I'll start with 71102. Outdoor advertising sign means any outdoor sign, and then it goes on, the advertising or informative contents of which are visible from the main traveled way of any highway on the interstate system or primary system in this village. So an outdoor advertising sign could be visible from an interstate or not visible from an interstate. 71106 says if it's visible from an interstate, you have to abide by these interstate regulations. 71107 says regardless of what it's visible from, here are the regulations that apply to the outdoor advertising sign. These are the ones that St. Bernard adopted. So if this sign were not visible from an interstate, it would not be subject to 71106, but it would be subject to 71107. The fact that it is visible from an interstate doesn't make it exempt from 71107. 71107 applies to all signs. 71106 basically says, regardless of what we've said down here, make no mistake that if this is visible from an interstate, you have to abide by interstate regulations.
So what rule of statutory interpretation would you be applying?
I think it's just a reading of the plain language here. I don't think we need to even get into any canons of statutory construction. So 71106, the definition of outdoor advertising sign, 71102A, says that it applies to signs visible from interstate or primary systems. 71106 is just if it's visible from an interstate, you have to abide by ODOT regulations. And if it's 71107 is, here are our regulations regardless.
It further restricts the type of signs because St. Bernard doesn't want to have digital advertising in their village.
Correct. And apparently this sign does comply with ODOT regulations because ODOT issued a permit. So 71106 is met, 71107 is not met. And it's never been understood to me why 71107 goes out the window when 71106 has been met, as opposed to them both even be complied with.
And I would assume that your position would be that the two sections are not in conflict.
Correct.
What about the argument that the village took the position in the Sixth Circuit that Chapter 7, Chapter 11 are totally different and operate independently of one another?
Yeah, so for that, I'll just start by saying that we were not involved in the Sixth Circuit case, so I'm just not, I've read the decisions, but I'm not familiar with all the pleadings. But my interpretation would that be there are separate standalone violations of 711 that could be prosecuted and pursued pursuant to 711, but they could also be brought under the zoning code when the zoning permit has been issued in a case like this. So they can operate independently, but 711 is incorporated into the zoning code through the expressway advertising section. And then just for the, I'll address the constitutionality issue briefly. as I said before, we've always maintained that this is a facial challenge, content-based, and so this court doesn't have jurisdiction to review it. So all of our constitutional arguments have always been in the alternative. As far as the res judicata arguments that we had made, they've been in the alternative to the extent that there was an as-applied or a facial issue raised in this case, that those had necessarily been determined by the federal court in the same factual and legal matter. It's basically the same claims were made to the federal court. They were decided there before a decision was made here. So the res judicata argument was just to the extent there ever was a constitutional issue, that's been resolved. And it has been reversed in the interim between briefing and argument, has been reversed. It was reversed on a single issue that has nothing to do with this case. It was the public signs exemption. Has never been addressed in this case. When the court reversed it, they reversed it for briefing on severability to see if the remainder of the ordinances could be severed from that public service sign definition. And so to the extent that there was a reversal, that really doesn't apply to what we're talking about here today. The federal court examined all those and upheld the constitutionality of all of the ordinances that are at play here and the harm that Norton is alleging to have suffered as a result of the ordinances. So I have about a minute left unless there's any questions. I'll just wrap up. Again, I just think it's simpler than we've made it. The billboard violates the St. Bernard ordinances. It's a violation of 711. 711 is part of the zoning code. So therefore, it's a violation of the zoning code. St. Bernard issued a permit to build this sign. What the sign was, when it was created, it went beyond the scope of what was in the permit. So they issued a notice of violation, gave Norton an opportunity to be heard. Norton appealed, by the way, pursuant to Chapter 11. They never, procedurally, at the administrative level, never said this should have been a Chapter 711. That the argument was that Chapter 711 doesn't apply, not that this should have been a Chapter 711 appeal from the first place. Norton was given a hearing. They were represented by counsel. They presented arguments and evidence, and it was basically the same issues that are being addressed here today. To the extent that a constitutional challenge has ever been made or that this decision could ever be called unconstitutional, they were given due process. So I don't think that there is any way that this court could rule unfavorably based on what's in the record on a constitutionality challenge to the decision. St. Bernard's decision that the billboard violates the ordinance is fully supported by the evidence. Given the standard of review here, strongly favoring affirmance, I think this court has to affirm. Thank you.
Thank you for your argument.
Your Honor, a couple of things. Number one is that if you accept the village's argument that 71106 says that interstate signs meet this requirement, and then you read into it in addition to other things, then it makes 71106 superfluous. Because if you remove it, what have you done? Because the signs that are on the interstate have to meet the ODOT requirements no matter what. So we're coming up with an interpretation that renders the entire section meaningless.
Well, that's the bare minimum, right? And then the village has further defined that you can't have a digital sign.
Well, that's not, but my argument is that that's not what the statute says. The statute doesn't say for signs that fall under 71106, you meet the ODOT requirements plus 71107. It just says the ODOT requirements and then it ends. And the village is reading into it that additional, which is why I referenced the example that I gave in the briefing down below, where we provided a copy of a code that says where you meet the ODOT requirements, you still must meet the requirements in this other section. So I think it's an addition to.
Doesn't the reference to the ODOT requirements make violations of the ODOT requirement enforceable by the village of St. Bernard?
I have not thought of that, Your Honor, whether.
It's not superfluous because it gives St. Bernard an enforcement on them.
I don't believe that the village has the ability to enforce provisions of the Ohio Revised Code through 711. I had not thought of that, though. With respect to constitutional scrutiny is not deference. This is a First Amendment case, and it's really clear Strict scrutiny is compelling governmental interest and narrowly tailored. The government bears the burden of proof on all points, whether it's strict or intermediate, and that's the difference. And so to say that...
What is your as-applied claim in this case?
So, Your Honor, a facial challenge would be that the law is invalid in all respects, and an as-applied would be as applied to this particular sign in this particular case. And so one of the cases that we...
Can you flesh that out for me? Like, where have you raised that claim, and what
Oh.
does it look like distinct from the facial
Yes.
claim that you raised in federal court?
Yes, Your Honor. So what we did was, in the briefing, we said that you're treating different forms of speech differently, so now you need a compelling governmental interest. They list those interests in their preamble. They say traffic safety, aesthetics, and other things like that. But then you have to show narrow tailoring, and that's where they ran afoul, because it's hard to say that, a digital sign is more or less aesthetically pleasing when it says a particular thing. And that's one of the cases that we had argued below that's from the 1990s from the Kentucky Supreme Court called Flying J. And what that said is when they invalidated Kentucky's digital regulations at the state level, they said, look, you can't say that a sign is more or less a traffic hazard or visually displeasing because it has the time and temperature versus the price of gas. There's no, it makes it hopelessly under-inclusive.
What you're speaking to sounds like a facial challenge. In fact, based on what I've read in this particular record, we don't know what the content of your sign would have been or what its particular attributes would have been. So what in the record explains how this particular ordinance has been applied to this particular sign in a way that you find to be constitutionally problematic?
Because, Your Honor, the order that, so under 250604, this court has the duty to determine whether the law is constitutional. We're not asking for an order that's like a declaratory judgment that in all instances that it's invalid. It's invalid as applied to these restrictions on us because we put in evidence that showed that there were other digital signs that were granted permission to operate, whereas ours were not. And so it's their burden of proof to prove narrow tailoring, compelling governmental interest, and to carry that constitutional burden. And what they argued at the magistrate level was that they weren't restricting free speech because they didn't tell us what we could or couldn't say. And that's not the constitutional test at all. And if you look at the transcript from the hearing with the magistrate, I mean, the whole of the constitutional analysis was just, I find that it's not unconstitutional. There was not even, now that has probably been somewhat obviated because Judge Pater took a different look at it, but when Judge Pater did that, he went beyond the administrative record and took evidence that would be beyond the scope of this. So what we've been arguing is that the law is not constitutional, but this as applied versus facial just has to do with the form of relief that comes out of the administrative appeal. And there's a case called City of Cleveland versus Posner, 2010 Ohio 3091, which is an 8th district case. But it says, although a facial constitutional challenge to an ordinance is improper in an administrative appeal, a driver is permitted to raise the constitutionality as applied to his case, and the trial court erred in failing to consider the as applied due process challenge. So that's what we're arguing, that as they impose the sections of 711 on us, that those must first be administered in the way that they're written, that the penalties and enforcement mechanisms and the hearing rights and the things that come from that must go in that order, and then the law must also be constitutional on top of that. And we never, we appealed to the BZA because that's the enforcement mechanism we got. But that's not the hearing that we were required to get. We were required to get a hearing before the law director, the director of public service and safety, or their designees. And so the fact that those people were present at a BZA hearing, the village is raising and saying, well, it's substantial compliance because they were there. Well, they didn't vote, and the hearing didn't go that way, and it didn't follow the procedure that they're required to follow. It didn't come from the officer that it was supposed to, and it came with a totally different enforcement mechanism. And then they want to incorporate by reference other sections into their zoning ordinance. And so all of that creates the error of how we got here. And so if the court...
Did you complain of that before the BZA?
Yes, Your Honor, and I'm always very cognizant of that too, because the BZA cannot, they cannot determine the constitutional issues because it's the practice of law. but yet we're stuck with the administrative record on appeal. So I go ahead and I put that in when I do those cases, and we did argue that, and that's in the record 150. So it's odd because they skip pages, but it's like 152, 154, 156, 158, and those put out all of the arguments that we raised at the BZA.
Thank you for your argument this morning. Thank you both for your arguments this morning. We will take the matter under submission and issue timely decision. Have a wonderful afternoon. Good morning.
Good morning.
This is In Re JG. Attorney Kane, would you like to reserve time?
Yes, I'd like to reserve 3 minutes,
All right.
please.
You can start whenever you're ready.
May it please the court. Margaret Kane on behalf of the appellant, JG. The principal question at stake in this case is whether the juvenile court erred in finding beyond a reasonable doubt that JG was the driver of the vehicle, which is an essential element of 2 out of the 3 case charges for which he was adjudicated and is highly relevant to his liability as to the 3rd charge, receiving stolen property. This case presents the unique circumstance where the trial court clearly lost its way in resolving evidentiary conflicts and rendered a verdict that embodied a manifest miscarriage of justice.
So this is manifest weight.
It is.
Okay.
Yes. The juvenile court's determination that JG was the driver of the vehicle primarily hinged on the testimony of HD and the testimony of Officer Collins, particularly Officer Collins' interpretation of his body-worn camera, which was admitted into evidence as State's Exhibit 5. I'll tackle the elephant in the room, which is HD's testimony, indicating that as a rear passenger in the vehicle, she testified that JG was driving. So typically, on review, the trial court's determination regarding the credibility of a witness is given substantial deference. When there's a manifest weight challenge, this court has the ability to review credibility, notwithstanding the deference given to the juvenile court. Here, I'll note that the juvenile court failed to appropriately resolve or consider the conflicts in HD's testimony and other issues of credibility, such as bias, that were raised by JG at trial and on objection to magistrate's decision.
Counsel, you raised a very interesting point in your brief about HD's statement regarding JG's shirt being off. Can you hone in on exactly how HD would have known that JG's shirt was off?
I am happy to address that. So that statement came when she was speaking with an officer at the scene of the crash. And the reason that I pointed to that particular testimony was that at the time that the 3 youths, including JG, fled from the vehicle, all 3 of those male youths were still wearing their shirts, and HD was in the vehicle.
And the body-worn camera footage backs that up, right?
Yes, that is very visible on the body-worn camera, and there's testimony also indicating that at the time that JG jumped over the guardrail to flee from the crashed vehicle along with the 2 other males, he was still wearing a white t-shirt. So when that statement from HD was initially made to Officer Collins at the scene, it was immediately following a brief period when Officer Collins conspicuously muted his body-worn camera, and immediately prior to that, it had become clear through listening to the body-worn camera and reviewing it that a different officer who was looking in the area for the youths who had fled had found 1 youth. Prior to that point, HD had indicated that she didn't know who She didn't really know the other kids that well. She didn't know their names. She didn't give any identifying information. Then they catch someone, and Officer Collins makes it very clear to HD that she needs to cooperate. Otherwise, she will potentially be charged with receiving stolen property for this vehicle, which was stolen. And then turns off his body-worn camera, goes and sits in the car where HD is sitting in the back seat of the police cruiser. And after a period of body-worn camera being muted, he gets out of the car, walks over to the passenger side of the vehicle, turns the body-worn camera back on, and asks HD, hey, was somebody wearing jeans with a green stripe? She proceeds to say, I think so. And also, that person was wearing a Gucci shirt, and he's the one who didn't have a shirt on. Although there was no way that HD would have known that sometime after JG had fled the scene, he had taken his shirt off. So the inference that I think can be drawn from that testimony or those statements to the police was that she had either overheard the body-worn camera, which indicated that the person they caught did not have a shirt on,
Or the radio.
over the radio,
Yeah.
yep. Or that there had been some kind of conversation that was not audible on the body-worn camera, given the very specific timing of the muting, that suggested that those were possible statements. And I know that is speculative, but it really undermines her testimony. Further undermining her testimony, though, is that at trial, when asked to identify JG in the courtroom, she starts to describe clothing that he was not wearing in court. She indicates that he was wearing a blue t-shirt and black shoes, and the prosecutor says, hey, hold on. We're talking about right now, not at the time of the crash. And she goes, oh, okay. And she starts to describe what he's wearing in the courtroom, and that's when they make identification. However, at the time of the crash, JG was wearing a white t-shirt and blue jeans with a green stripe. He was not wearing a blue t-shirt.
In fact, no one was wearing.
No one was wearing a blue t-shirt. And so it's a little unclear what exactly that means, but it undermines the identification of JG as the driver, especially in light of the fact that this was the first time she had met JG, as well as one of the other youths. HD only knew one of the three youths who were in the vehicle. The relationship with that individual has been suggested was maybe a romantic relationship. HD's description of the relationship shifts a little between her statements on scene versus at trial, but there was one person she was close with.
What does the body-worn camera show with regard to who exited the vehicle first through the driver's side window?
So it is very unclear. At the point that the body-worn camera starts, the vehicle has already crashed. It's not clear exactly how long the vehicle has already been crashed. And as Officer Collins is getting out of the vehicle, you can actually see all three youths. And so one youth, JG, is sort of near the front door of the vehicle in the process of jumping the guardrail. Another youth who the officers described as a heavier set black youth was near the rear side door of the vehicle, getting ready to try to jump the fence as well. And then the third individual, who was initially identified multiple times at the scene by Officer Collins as the driver. So he was a shorter black male wearing a gray sweatshirt and dark pants and a black knit hat. He was in the process of exiting the driver's side door as Officer Collins approached. And you don't see where the other two youths exited from. The state contends that they necessarily had to have exited from the front driver's side door because that was the only door that was open at the time that Collins reached the vehicle. Notably, however, they could have just closed the door.
Counsel, I was able to pause the video very early on in the officer's approach. And what I saw was a single young person in the video, the shorter, heavier set person. And he was back by the tail light of the car. The officer's door was obstructing some of my view of the rest of what was in front of him. What, if anything, does that suggest about who got out of the car first?
So from my view, what it suggests to me is that as JG testified, he got out of the back door. The other heavier set youth got out behind him, which would explain why JG didn't know that how the door got closed. That youth got out from behind him. Maybe the driver was taking too long to get out, shut the door, and that's why that heavier set youth was standing sort of near the back of the door, and JG was jumping over the guardrail. As he did that, the heavier set youth comes up and starts to jump over the guardrail. You can tell that in that process, EW, who JG identifies as the driver, is not able to get out the door, which suggests that they couldn't have all come out of that driver's side door. The state's theory that all three youths exited and that JG exited first doesn't make sense with the body-worn camera. But the body-worn camera, aside from HD's testimony, which I think is very incredible in light of sort of the circumstances of how she was interviewed, the lack of information about the original ID that's not captured on body-worn camera, it's not explained anywhere, as well as her inconsistencies at trial. The body-worn camera is what the officer hinges his decision to charge JG with.
Because he jumped first, right?
He jumped over the guardrail first, yes.
Okay.
And it also is the basis on which the juvenile court determined that JG's testimony was not credible. And that was actually the only basis on which they said that JG was not credible when he testified at trial. Notably, regarding credibility determinations for HD, the juvenile court judge actually didn't render any kind of credibility determination about HD's testimony. The magistrate indicated that she felt that HD's testimony was credible, but she didn't resolve any of the conflicts or consider the challenges that the trial attorney had raised to her testimony.
Why did the magistrate find JG not credible?
She found that JG was not credible because she said that his testimony that he exited through the rear driver's side door was not consistent with the body-worn camera. And so it all sort of hinges on this assumption that all three youths had to have exited through the front driver's side door, even though that is clearly not visible. We don't know how JG or the heavier set youth exited the vehicle because that is not captured on body-worn camera. And so that is just the assumption that has been drawn, but it doesn't actually make sense because if all of them had exited from that door, you would actually think that the heavier set youth exited first, followed by JG or some other combination.
But if we don't know, how is the trial judge losing her way when she sees that JG jumped first? And it would be logical to conclude that he exited first if he jumped first.
Not necessarily based on sort of the angles and where everything is connected in the body-worn camera, because it's clear that only one youth can exit the vehicle at one time. But additionally, that fails to consider the testimony of JG, who indicated that he got out, and that I think would also be supported by the evidence. And there's a similar case that deals with very similar circumstances called State v. Weatherly out of the 2nd District, where similarly the photographic evidence that was introduced on which the officer determined that he could tell which of 3 occupants in a stolen vehicle was the driver, and the trial court in that case accepted the officer's testimony that, like, yeah, this photographic evidence, you can determine where each of the occupants was based on this. But on a review by the appellate court looked at the photographic evidence that was offered and noted this doesn't actually prove where anybody was in the vehicle. And in this circumstance, it's very similar. And this is also distinguishable from another case, State v. Rhines, where there was testimony about who was the driver of a crashed stolen vehicle. And in that case, a person watched the prosecuting witness watched the crash happen, saw the defendant get out of the vehicle, proceeded to follow the defendant, and he had gotten out through the driver's side window. And then the passenger in the car also got out the driver's side window. But in that case, there was testimony that the passenger's side door couldn't open. And that's why the passengers had to get out of the driver's side window. There was also just much more clarity because somebody was there and actually saw both people get out. In this case, there is no evidence about who got out.
Except for HD.
Except for HD, yes. And again, that is why, and I do recognize that manifest weight
Counsel.
challenges are very difficult.
Counsel, I'll give you 30 seconds to
Okay.
okay?
So I'll reserve my remaining 3 minutes, but I'll just say that, we ask that this court weigh the evidence and find that the juvenile court lost its way and remand this case back down to the juvenile court for
Can I
the
ask a
trial.
quick, are you abandoning your sufficiency argument?
Yes. Thank you.
Thank you. Good morning.
I wanted to address what opposing counsel referred to as the principal question, which is here the manifest weight argument. And throughout the course of her argument, there's something that she said specifically, which is that we don't know how the youths exited because it's not shown on camera. That's kind of what the appellant's manifest weight challenge boils down to.
And also, we need to say that HD was not credible, that JG was the operator of the vehicle.
Right. Ultimately, I think what it boils down to is that the trial court, as all trial courts are required to do, is they had to make a determination on the sufficiency of the evidence, the credibility of the evidence, and make inferences when it comes to holes in the evidence that did not exist, or where there were contradictions in some of the evidence, make a determination of those contradictions, and then ultimately come to an adjudication based on the evidence that exists.
Aren't we kind of working backwards here? Because we don't even know in what order they exited the vehicle, but the trial court is inferring, based on how they were standing and their proximity to the car and the positioning of the car door, the trial court is inferring that JG was the first one out of the car. And then from that, it's making an inference that because JG was the first one out of the car, that JG had to be the driver. Isn't that the logical progression of interpreting the body-worn camera?
I think if you were just interpreting the body-worn camera, I would submit that, and I would agree with counsel, that the body-worn camera doesn't demonstrate who's leaving. And so what I would say is that if we were, based on what the trial court had to do was take the testimony of all of the witnesses and make a determination. The officer testified that the first person to leave the driver's side door was the person who he believed to be driving the car. It lined up with the testimony of HD, who testified directly that that was the person who was driving the car. But also, when it comes to the court, I would agree that the court had to make some sort of inference based on the testimony of the witnesses, but I do not think that anything that is shown on the body-worn camera directly contradicts the inferences that the trial court made. That is to say, I don't think the trial court lost its way in determining, based on, even if we were just focusing on Officer Collins' testimony, that the first person, that all of the youths left from the same door. The person who left the door first was the person who was driving. In the body-worn camera, you can see that, at least at the time that we can see the body-worn camera, that the appellant is furthest from Officer Collins. He's the first one over the guardrail, and he's the first one to run away down into the woods, which would all support the inference the person who was driving. I don't know if I properly answered the.
You
the court's
did,
question.
absolutely, yeah. Those are known facts, right? We know
Right.
that when Officer Collins arrived on the scene, JG was the furthest away from him. Known fact. We know that JG was the first person to jump over the guardrail. Known fact, right? We know that JG was subsequently found in the park and that he initially denied being in the car. Known fact, right? And then we're making some inferences, or the trial court did, make some inferences from those known facts and from watching the body-worn camera footage as to what those facts mean.
Correct.
And then we supplemented that, or the trial court did, with the testimony of HD in terms of who was actually driving.
Correct. As often I think it's required to do is to make inferences, because as I'm sure this court is aware, not everything that's always captured, whether it's body-worn camera or surveillance, necessarily shows directly what took place. I guess in addition to my argument that there's nothing that's captured on the body-worn camera, the testimony of the witnesses that would contradict the route that the court took. Most of what opposing counsel argued was trying to undercut the credibility determination of the court as to Collins and HD's testimony. There was some question, Your Honor, that Judge Kinsley, that you had asked about the turning off of the body-worn camera and what HD had told the officer in terms of what it is that the appellant was wearing. I want to make clear that I don't think that goes to who was who was actually operating the vehicle. The officer never asked, was that person who was wearing the Gucci shirt or the white pants operating the vehicle? There was a time where the officer's body-worn camera was turned off. When it came back on, the officer asked, was there a person who was wearing a light striped pants? She says, I think so. He was wearing a Gucci shirt. That would have been the person who had the shirt off. I'm paraphrasing slightly. But even if she had heard, for example, hey, we've got a person here who's got their shirt off and they're wearing a white stripe and pants, and she made that connection on her own. Oh yeah, the person with the white stripe and pants was also wearing a Gucci shirt. He must have taken that off. Ultimately, I don't think it matters. There was nothing connecting that testimony on the scene, that is, to him being the person who was driving. And in addition, it's not contested that he was on the scene. Although he told police originally that he wasn't in the car, he ultimately admitted that he was there. And so it's not as if it's in question that whether he was not. In fact, the confirming of the Gucci shirt, I think, would actually bolster her credibility in terms of the fact that she knew who this person was and could identify him as the driver, which is ultimately what she did.
So this wasn't anything nefarious. It, in your position, just appears that she pieced something together about what was going on.
Yeah, and I can't say for certain. I mean, obviously, with the body-worn camera audio being turned off, I don't know exactly what she may or may not have heard. But I guess it stands to reason. An inference that I could make is that perhaps she heard that someone had their shirt off, had a pretty distinct set of pants, and she made the connection of, I recognize that set of pants. It went along with that shirt, which she did confirm. And it was confirmed that he had taken off his shirt, which we argue in our memorandum is evidence of, which would be further evidence indicating his knowledge of that the car was stolen, which goes more to appellant's second assignment of error.
And then what about this argument that she identified clothing from the stand that neither matched what JG was wearing in court that day, nor anyone's clothing at the time of the accident?
I think ultimately that would have to be a determination that dealt with the weight of her testimony when it comes to the identification. The court certainly could have considered that. But ultimately, even if it had been months and months prior and she forgotten exactly what he was wearing at the time, in terms of, as the court stated earlier, no one was wearing a blue shirt on the body-worn camera. Even if she had misremembered exactly what he was wearing, she was able to testify on the stand that he was the person who had been operating the vehicle.
And could the state have proven its case just with HD and not the body-worn camera at all?
I think in terms of the identity of the operator, to that element, I think the court could have just simply relied on HD's testimony. Assuming that it found HD credible, it could have found that element. But in terms of some of the other elements of some of the other charges, I think that Collins' testimony or the body-worn camera would have been necessary to meet some of those other elements. But as long as we're talking about just the identity of the person operating, I think the court could have used HD's testimony alone to establish that, presuming that she found HD credible. As to the second assignment of error, which was the evidence of the knowledge that the car was stolen, what I would say is that opposing counsel in her memorandum made reference to a case that involved a credit card that had been used previously at a grocery store and was ultimately found in the possession of another person. Both this court and other courts of Ohio, as you can see from our memorandum, demonstrate that a motor vehicle is substantially different than other pieces of property, and the use of a motor vehicle to effectuate an escape from police is a demonstration of guilty knowledge, and therefore guilt when it comes to the knowledge of whether or not a motor vehicle is stolen. In fact, JG's testimony establishes alone that he understood although he says he was not operating, he said as soon as they took off from the police, he even says, I knew at that point that the car was stolen, in connection with, I think, the other things that he testified about. But I do think there is sufficient evidence for these charges, and I don't believe that the trial court lost its way when coming to its conclusion for the adjudication. There was a case that was cited by opposing counsel, the Weatherly case out of the 2nd District, that dealt with an officer's ability to make a determination from a distance as to who was operating the vehicle. I don't think that case is applicable here because, unlike in Weatherly, we have direct testimony and circumstantial evidence that did not exist in that case to determine where each of the occupants was sitting. We have not only the route that we took through Collins' testimony and body-worn camera, but we also have the testimony of HD who explained where everybody was sitting. If the court has no further questions.
Thank you.
Thank you.
Your argument this morning focused quite a bit on the credibility of HD's testimony.
Yes.
Okay, so if we were to agree with you, why isn't then, well, let me switch that around. You also focused on the video, right? So if we were to put the video aside and any inferences made by the trial court, right? At the end of the day, then it comes down to the credibility of HD. What within your argument would make it so clear that on manifest weight, that the evidence so undermines, that it's that exception of manifest weight, that it so undermines the credibility of HD?
I think that it comes down to the cumulative effect of all of the various parts of her testimony that made it lack the degree of credibility necessary to prove beyond a reasonable doubt that JG was the driver. So you have inconsistencies between her original statements to the officer and her statements during trial. We have, in addition to that, the potential bias, so the officer, and pressure from the officer. So the potential bias being both that she was fearful of getting in trouble and the officer pressure of you need to identify somebody, otherwise you are going to potentially be facing a charge regardless of whether or not you knew the car was stolen. And then the other bias being that
What you're calling bias is really the pressure, is what you're saying?
I would say that there's the pressure and then there's the bias, and the bias being that, she had one other person in the vehicle who she was close to. She did not really know the other two people. If there was anyone that she was going to want to protect, it would be the one person who she knew, who she identified as being called Dave, who she claimed was in the back seat with her.
Is this the person that your client claimed was the driver?
No, Dave is someone that my client identified as a friend of his who was seated in the front seat, but my client indicated that it was his understanding that Dave was HD's girlfriend. And my client identified EW as the driver. EW was the individual who officers originally identified wearing the gray sweatshirt and the black hoodie and the dark pants, or the black cap.
So HD wasn't trying to protect the person that your client identified as the driver?
Correct.
Okay.
Yep. The other thing that I'll note is that, of the 3 youths who fled, so if we're looking at inferences and circumstantial evidence, of the 3 youths who fled, JG was the only youth who was caught. Shortly after he was caught, officers terminated their investigation of the scene. They stopped looking for the other youths, despite the fact that JG, when he decided to come clean and be truthful about being in the vehicle, identified the very person that Officer Collins originally believed was the driver to be the person who was driving. The other, I just want to make sure that I'm touching on all of the notes. The other thing that I just want to highlight regarding the second assignment of error, unless there are questions about the first, but regarding RSP, the state is correct that merchandise of other natures is treated differently than vehicles. In this case, however, we're talking about a passenger of a vehicle. And so if we are looking at JG as a passenger, what is crucial for proving that he could be adjudicated of receiving stolen property, the state would need to prove that he acknowledged the vehicle was stolen and that he remained in the vehicle, retained the vehicle for some duration of time after knowing that the vehicle was stolen. Based on JG's testimony, I would argue that he first learned or became aware that the vehicle might be stolen at the point that his friend EW started speeding up and failed to comply with the officer's orders. As soon as the vehicle came to a stop because it crashed into the guardrail, JG exited the vehicle. He fled because he was afraid of getting arrested, but that doesn't mean that he remained in the vehicle for any period of time after becoming aware that it might have been stolen. Both HD and Officer Collins also testified, in addition to JG, that there was nothing about the vehicle that would have indicated to somebody who that the vehicle was stolen. There wasn't a stripped steering column, there were no broken windows, there was nothing about the vehicle that would have suggested it was stolen, but except for the way the driver responded to being signaled by police to stop. And so it would be aligned with our case law. In Ray Brumfield, this court has noted that merely being present inside a stolen vehicle is not enough to support an adjudication for receiving stolen property when the person is a passenger. And
So everything hinges on the determination on whether he was a driver, is what your argument is based on.
yes. And based on all of these factors, it is our contention that the state did not prove beyond a reasonable doubt that JG was the driver of this vehicle. And we would ask you to remand. Thank you.
Thank you both for your arguments this morning. We'll take the matter under submission, issue a timely decision. For the students that are here, I believe we're going to be remaining here, right? But we're going to be stepping out in a moment. Feel free to stretch your legs. I know it's been a long morning, and then we'll come back, okay? And that concludes our arguments for this morning.